Good afternoon and welcome to this month's meeting of the Divorce Support Club with me, Claire Macklin, and today I'm joined by Lev Briaco, and we're going to talk about the divorce process and hopefully explain it to you so that you can understand exactly how it works. Lev, do you want to quickly introduce yourself, and then I'll do the same, and then I'll give a quick introduction and we'll get cracking with some of the questions.
Fabulous. Yes, so my name is Lev Briaco. I am a chartered legal executive at Ian Walker Family Law. We are a family law specialist firm, meaning that we only specialise in this area of law. We cover everything that falls under the family law umbrella, which can include children disputes, divorce, separation between individuals who are not married, as well as cohabitation agreements, separation agreements, and pre and post-nuptial agreements. So anything that falls under the family law umbrella, we can assist you with.
You very much. And for my part, I'm Claire Macklin. I work quite closely with lots of Lev's colleagues at Ian Walker Family Law to provide emotional support to people who are going through separation or divorce, to help you to begin to concentrate on yourself rather than your ex, to find calm and clarity, to get control of your emotions and make really good choices, to communicate perhaps more effectively with your ex, and also to begin to create the blueprint for a new life post-divorce. So we run these sessions monthly to give a safe, informal place for you to get information, to get guidance from us as experts, and so that you feel that you're not alone going through this process. And today what I've done is I've collected lots of the questions that I often get asked by my clients, the things that perhaps are confusing around the divorce process. Because when you're getting divorced, it's not something that any of us ever really expected when we get married. It's not something that many of us have chosen, and it's an alien world, and it might be full of lots of jargon. There's a strange process to go through, and it's something you never thought you'd have to do. And there's a lot of misinformation as well in the media, or in TV dramas. And you may be getting lots of different information from friends and family as well. So what we want to do today is I'm going to ask Lev lots of the questions I get asked in my sessions, as though I'm my client asking them, and Lev's going to hopefully explain and make everything just a little bit clearer for you, and for you as watchers. So I think my first question that comes up often, Lev, is, can I get a divorce myself just by applying online? I've had a look at the government website. It seems pretty easy. Does it cover everything? And does it matter which one of us applies?
Yeah, very, very, very good question, Claire. It's a question that we're asked quite often ourselves, and I think to fully answer that question, I think it's important for me just to refer to a little bit of law. So in April of last year, we had a new piece of legislation come in, and it's called the Divorce, Dissolution and Separation Act 2020. Prior to the introduction of that act, we had a fault-based system where you had to cite a reason as to why you are getting divorced, and depending on which factor you choose, you might have to provide some information. Further to April 2022, all of that has been abolished. So we now have a new non-fault system in place. The confirmation that has to be given to the court is that you feel that a marriage is irretrievably broken down. In relation to, for example, whether you can apply for divorce yourself, the quick answer to that question is yes. The new legislation is designed in a way to try to make it more user-friendly for individuals who are not within legal circles. So they've got rid of a lot of the archaic terminology, which quite frankly didn't make a lot of sense to a lot of people, and introduce new terminology which is a little bit more simpler to use. So the application is done, for example, or can be done through the government portal. And it is drafted again and set out in a way that should be easy enough to use. Under the old legislation, there used to be many reasons for why you can object to a divorce. Again, all of that has been put to one side. The only ground for objection to a divorce under the new legislation is on jurisdictional basis. Most of our listeners won't fall into that category. I would say that if you do fall into that category, it would be prudent to get some legal advice, because we're now going to more kind of complex areas of law. So the divorce itself, is a fairly straightforward process, I would say. But there are still a couple of knacks that I think individuals need to be aware of. The biggest point that really crops up with us is surrounding service. So one of the things we will cover kind of in due course is kind of divorce process itself. But the knack that I'm referring to here is that when an individual issues an application, it gets sent to their spouse if they're applying by themselves. There are still service requirements insofar as your spouse needs to be aware that you have started a divorce against them, and therefore they usually need to complete a document. Now, if they don't complete the document that is sent to them by the court, there are still rules in relation to the service of those documents upon them. From my perspective, and I appreciate it won't cover everything, but if you are concerned that your spouse isn't cooperating or isn't going to cooperate, in a nutshell, the service requirements are that they are served, or they can be served by post and email. But I think if your spouse is being difficult, I think it's prudent that you seek legal assistance.
Absolutely, thank you. Is there such a thing, and I've seen this in the media, is there such a thing as a quickie divorce?
The quick answer to that is no. I think this is a little bit of a myth and a little bit of a marketing strategy, and I think that there are a lot of firms out there that market themselves as a quickie divorce. So in the divorce process, there are stages which have to be complied with, and there are time restrictions in relation to when certain applications to progress your divorce can be made. Unfortunately, those timeframes can't be hastened up for the vast majority of people. Now, the reason I say vast majority of people is because there are minor exceptions, but they are very niche exceptions. So for most individuals, once they issue their divorce, there is a 20-week wait period. And there is not a lot that can be done to hasten the 20-week period. Then we reach the conditional order stage, and then there is another wait period of 6 weeks and 1 day before they can apply for the final order. So those periods, unfortunately for most people, we can't hasten them. So in terms of kind of looking at the whole divorce process, we are looking in the region of 6 to 9 months for most individuals. So to return to your question, is there such thing as a quickie divorce? The answer for most people is no. And yeah, you're looking at 6 to 9 months.
Yeah. Okay, so that kind of covers how long the process can take. You mentioned very briefly the main stages. So could you elaborate a little bit more? What are the main stages of going through the divorce process?
Sure, not a problem. So from the outset, an individual has to make an application for divorce. Now, under the new law, an individual can make an application by themselves, and when an individual applies for divorce, they're known as the applicant, with the other spouse being the respondent, because obviously they're in receipt and they have to respond. Under the new legislation, it also allows individuals to apply as joint applicants. The reason behind this is that the law appreciates that sometimes the reasons people's marriage breaks down is not due to a fault of either party, and both parties may simply have drifted away, and therefore they can apply jointly. So if an individual applies by themselves as a sole applicant, once a divorce is issued, a document known as an acknowledgement of service is sent to the spouse. It is to the extent of saying your spouse has applied for divorce. please confirm that you have received a copy of divorce application and that you agree for this to continue. So once the divorce is issued, it gets placed into this 20-week hold period. The whole period is to allow the parties time to reflect upon whether this is actually something that they want to go ahead with. Once the 20-week period has passed, the applicant will be able to apply for something that's known as the conditional order. It used to be called Decree Nisi, but again, it's the removal of the archaic language, so it just makes it a little bit easier. The conditional order, I guess the easiest way of explaining it is like a middle stage of divorce. It is where a judge has looked at all the documentation and has confirmed that, yes, you are entitled to divorce if this is what you wish to do. Once the conditional order is pronounced, 6 weeks and 1 day after, you can apply for something that's known as the final order, or what it used to be called as the decree absolute, which is where your marriage dissolves, meaning that you can remarry. So the three key stages in any divorce applications: the issue of divorce application, applying for the conditional order, and then applying for the final order itself. The slight niceties if you're applying as a joint applicant is that every stage has to be consented to by both parties. So the stages are still the same, but again, both you would need to log in through the portal and say yes, effectively, to making the applications.
Right, okay. And those time periods, so a question that I get asked a lot is, are those time periods deadlines? So I have to apply for my conditional order by that date and my final order by the next date, or are they minimum periods?
Yeah, no, that is a very good question. It's something that we deal with again quite often. The quick answer to that question is yes and no. So the return of the acknowledgement of service has a deadline, and if you're a respondent, you should look to comply with the deadline in returning the acknowledgement of service. The other dates within the divorce are not deadlines. They are simply check markers or checkpoints as to when you can apply for the next stage of your divorce. Now, I think it's important to understand that, I think from a legal perspective, the way that most cases pan out is that a divorce has progressed up to the conditional order stage and then left at that stage until the finances can be resolved. And then once the finances are resolved, we then apply for a final order dissolving your marriage. Now, I think some individuals prefer to get married, prefer to get divorced sooner before resolving the finances, and that's fine. The rationale behind that kind of strategy of leaving it at the conditional order stage is largely revolving around the financial implications of the final order, i.e. being divorced. Now, while you are married to your spouse, for most individuals, you are their next of kin. And in the event that your spouse does pass away before the divorce is finalized, for most individuals, they'll be financially better off than being divorced. So I think some consideration should carefully be given as to whether you want to be divorced before resolving the finances. I think most legal practitioners would agree that it would be prudent to resolve the finances before finalizing your divorce.
Yeah, so it sounds as though there are different strands. So there's the kind of paperwork strand, which is filling in all the forms and putting the things to the court, and then there's the financial strand, which kind of runs alongside, and then at the end, they dovetail together.
Yeah, very, very much so. I explain to a lot of my clients that the easiest way of thinking about divorce and finances is that they are two separate things. The divorce purely deals with you being able to be or to get remarried, and the resolution of finances deals with your financial division from your spouse. Now, it is important to understand, again, just because you are divorced, it does not mean you're no longer financially tied to your spouse.
I think that's a really important point to make, isn't it? You may be officially divorced in terms of the paperwork and the marriage is over, but unless you come to an agreement around your finances and file that as well with the court separately,
Mm.
but at the same time, potentially, those financial ties continue.
Yes, very, very, very much so, very much so. And I think that there's been a lot of cases where something like that has happened, insofar as let's say a couple have got very limited assets and they choose to do the divorce but not resolve the finances, and then at some point down the road, the finances will change. One of the
Somebody wins the
parties,
lottery, or
someone wins the lottery, someone receives an inheritance, and then
yeah,
the financial landscape becomes very, very different.
yeah. So for certainty, um, getting your finances sorted would be a wise thing to do. It sounds like. Okay, thank you. Um, Another question I get asked a lot is, do we both have to have a solicitor? Why can't you just act for both of us?
Yeah, very good question. So the answer to that question of do you both need a solicitor is no. Quite frankly, the answer to the question is neither of you really need a solicitor. It's just I'm very experienced at what I do,
Yeah.
and it's usually prudent. So in the same breath, I think having two solicitors with both parties legally represented, it does make the process for most individuals a lot more smoother, simply because of the fact that you have an individual there explaining to you the process and the relevant considerations. With regards to the second kind of part of your question of can you act for both of us? This is a little bit more difficult to answer. It used to be the case that a solicitor cannot represent two clients. And the rationale behind that is ultimately one person cannot have both parties' best interests in mind. Now, there has been a new concept which has recently been introduced, and we do have quite a few of myself and my colleagues who are now practicing under this. It's known as resolution together. The idea behind resolution together is that two individuals can have one solicitor, and that one solicitor will assist those individuals, usually through meetings and kind of discussions in relation to kind of points of law, and guiding them and bringing in relevant other professionals as and when required.
Yeah.
The very big benefit of resolution together is that both parties are effectively receiving or hearing one set of advice. Divorce and resolution of finances is a very subjective area. It's not a mathematical calculation, and therefore the parties' individual circumstances can and should be taken into consideration. When you have two solicitors, sometimes what tends to happen is that you get slightly different advice within the spectrum of where it could end, which can sometimes cause divisions. The benefit of
Yes.
resolution together is that you're receiving one set of advice. So a solicitor can represent you both under the umbrella of resolution together. So yes, it's possible, and I think a lot of people are successfully doing it these days.
Yeah, it's a really interesting new development in the area, so it's definitely worth exploring. If your case is one that would fit into that model. So the next question that comes up a lot is how much is this likely to cost? And is it possible to have a fixed fee divorce, effectively know how much it's going to cost from the start?
Hmm. So again, in relation to the divorce itself, for most individuals, the only fixed fee that an individual has to pay is the court fee. So at the moment, the court fee is £593. If you are on a lower income, there is something that's known as a fee remission. So if you Google fee remission, it will take you to the government website, and it will give you a code which will allow you to either remit the entirety of the court fee or a part of it, depending upon your income. We at Ian Walker, we don't offer fixed fee divorces. I'm aware that other solicitors do. The rationale behind not offering a fixed fee divorce is quite simple. We don't know at this stage, obviously, in what direction your divorce is going to go. Insofar as, if you went to a mechanic, and a lot of work needs to be undertaken on your car, you will naturally pay a little bit more than if it did not. With a lot of my clients, the fixed fee can actually also work the other way, insofar as it's actually works out or can work out to be cheaper doing it on an hourly basis than a fixed fee, which is a standard fee applicable to cases. My warning would be the solicitors who offer fixed fee appointments. It's a middle point between really difficult cases and quite straightforward cases. So you might actually be paying more than you would do if you instructed on a normal hourly basis.
It's really interesting. And in respect of that, another question that I get asked quite often as well is, can I do the online bit and do the paperwork, filling in the forms of that, and then work with you on an hourly basis around helping me to sort out my finances, deal with issues around the children and that kind of thing? So kind of mixture.
Yeah, absolutely. Yes. Again, the way that I view things personally is it's an individual's divorce. We will do it the way that an individual is happy to do it. So if an individual is happy to deal with the divorce process themselves and only bring us on in relation to the finances, that's absolutely fine. If you want to hand the reins over for everything, that's all absolutely fine. Again, it is very much client focused. It's about what you want. It is your divorce, and we will do it the way that you want it to be done within the ambits of what the law allows us to do.
Yeah, I think that's a really important point to note as well for our listeners. Every divorce, and my experience says this too, every divorce is different. Different individuals, different financial situations, different family dynamics. And so that's why it can be so dangerous sometimes to listen to people who say, well, when I got divorced, I did this and you need to do that. And because everybody's is different. So it's worth taking that step back and getting some advice that's applicable to your case specifically, not your friend down the road.
Very much so. Very much so.
The next question I get asked sometimes is, I'm in a civil partnership rather than a marriage. Are the rules the same?
So the law has caught up with itself. It is where we are now. And the quick answer to that is yes, it is. There is no difference now. There used to be a difference, but to anyone making that type of application now is yes, the laws are exactly the same to both.
Right, thank you. So you've explained how the process works in terms of the paperwork and so on. How do we go about sorting out our finances? And also the other question, which is also another big question, I guess, is how do we go about sorting out what happens with our children?
So resolution of finances, to start off with, is a little bit more trickier than divorce, and a lot of my clients will utilize me for the resolution of finances. Again, the answer to that question is it largely depends on how you want to deal with things and how much involvement you would like from us. One of the most important points, and I generally see this as divorce and resolution of finances will, for a lot of people, materially affect their future.
Yes.
For that reason alone, it is important that an individual makes an informed decision in relation to what they're agreeing to. And the way we usually reach an informed position is by way of disclosure. So again, to avoid court proceedings, what we do is undertake something that's known as voluntary disclosure. Voluntary disclosure largely consists of both parties gathering an outline of their finances and their supporting information. That documentation is exchanged, and on the basis you are satisfied that your spouse has accurately disclosed their financial position, you can then receive legal advice from someone like me, and then we can look at negotiating a settlement. Now, again, that is ultimately an option. For individuals that don't want to go down the route of voluntary disclosure, even though it's advisable, I appreciate there isn't a model that fits everyone.
Mm.
Ultimately, if you don't want to undertake voluntary disclosure and you're simply happy to negotiate a settlement with your spouse, if an agreement is reached, a solicitor can draft that legal agreement for you and look
Right.
to send it for approval of the courts. Now, the two very key points that I think it's prudent to highlight to our listeners is the first one being, if a legal advisor doesn't know what each of you have accurately, it's almost impossible for us to give you an indication as to whether your agreement is fair or not. So by reaching an agreement directly with your spouse without having any disclosure, you are taking the risk of, one, something might not have been disclosed, and two, it might not be fair upon you. A lot of my clients, and I think generally a lot of people, one of the things that's regularly overlooked are pensions, simply because of the fact that pensions aren't tangible, you can't see them, and it's something usually in the back of people's minds.
Mm.
Again, a lot of my clients, the pensions can be the most valuable assets, and pensions are a little bit of a minefield because there isn't a one type of pension. There are so many different types of pensions, and each of these types of pensions all have different benefits. So if you choose to go down the route of trying to negotiate, I think it's something that you have to tread very carefully.
Mm. Yeah, go into it with your eyes open.
Very much so. The second element I think is important to understand is that ultimately a financial agreement has to be approved by a judge. A judge can reject your financial agreement if the judge does not feel it is fair. That is also the case regardless of both parties want a financial agreement to go through, the court can still reject it.
Right. So even if, let's take a very extreme example, even if let's say one spouse agrees to give up absolutely everything and not take anything from the marriage at all, so no assets, no share of anything, walks away from the family home, etc., and the other spouse therefore keeps everything, even if they've agreed to that between themselves, I mean, there are other issues behind that, probably in terms of power balances within that relationship and so on, that might be worth exploring. But the court would be likely to say that's clearly not fair. We reject that, and you need to then go back into negotiations. Is that how that would work?
Yeah, very, very much so. I mean, the court and judges are bound to find a fair situation.
Yeah.
A lot of individual, what you've touched upon there, power imbalances, it's looking as to why a given agreement has been reached. So sometimes individuals will make a decision in the heat of the moment that they might regret at
Yes.
some point down the road, even if there isn't a power imbalance. The court act as a safety measure
Yeah.
ultimately to ensure that that doesn't happen.
Yes. Yes. That makes complete sense. And so that kind of covers how you sort out the finances. What about the children? How does that work? Because that's kind of third strand, isn't it, for many couples? You're sorting out paperwork, sort out the finances. We need to know what we're doing around care for our children.
Yeah. In relation to children, especially in the kind of divorce forum, what the law says is that a judge has to take into consideration any minor who's under the age of 18
Right.
in the resolution of finances. From a financial perspective, a financial court would not go as far as dictating where the children should live or how often the children should see the other parent. On a practical level of, if you're in a position where you can't agree or you don't know what's going to happen in relation to child arrangements, general rule of thumb is that the courts prefer not to impose an order in relation to contact if an order does not have to be made. The rationale behind that being ultimately, it's mum and dad who will know what's best for their children, rather than a judge who will see you for X number of hours throughout your case.
Mm.
So that there are many different ways of looking to try to reach child arrangements. The most obvious one is obviously speaking with your spouse. You know, if an agreement is reached, then fantastic. It doesn't need to go any further. Now, for the listeners that a little bit more apprehensive about or not able to sit and have that conversation, there is always the option of mediation. A
Mm.
mediator acts as a middle person in order to guide discussions, and obviously solicitors can assist with that if required. Ultimately, a court application in relation to resolving child arrangements, in my eyes, should be the last avenue to be explored.
Yeah.
Not only because it's stressful, but it's also an expensive process in relation to that. I think in order to explore that in a little bit more detail, I think we'll need to explore that in a different
Yeah, in
seminar
another
in relation
session.
to children's side of things.
Yeah. One
Um,
thing I'd say around that is that, you know, there's so much evidence, isn't there, that children are best served by not being caught in the middle of of a big conflict between their parents that ends up in a courtroom. But anything you can do to create parenting plans, work with perhaps coaches, work with mediator to come to a position that you can both live with, is probably very much the preferred way forward. And I understand as well the courts are overwhelmed with this work as well at the moment, so there are massive delays. I think I read something in the paper the other day that, you know, there are children who are waiting for a year, 18 months to find out where they're going to live, and that's really not a good place for those children to be.
yeah, very, very much so. Unfortunately, the courts are still behind further to pandemic. I think
Mm.
locally to us in the southwest, I mean, I'm regularly seeing 2-3 month delays before the first hearing.
Yeah,
Again,
yeah.
and I think a lot of issues can be resolved
Mm.
with both parents working together with the assistance of legal advice.
Yeah,
So the more that can be resolved, then the better. Obviously, there might be issues which you can't reach a resolution on, which is where court is required. But again, the more that can be dealt with between parents, the better in my eyes.
yeah. Thank you. So another question that comes up and is around health impairments or illnesses and health conditions that might affect how your finances are result how your finances are resolved. Can you talk a little bit around that?
Yeah, no problem. So
Thank you.
when we look at resolution of finances, there is a list of factors that a court has to take into consideration in order to determine what is fair. I think well, these are known as Section 25 criteria because they come from Section 25 of the Matrimonial Causes Act 1973. Now, one of those factors is health impairments or the well-being of a party. Now, health impairments are an umbrella term,
Mm.
and they encompass everything from physical impairments to mental impairments as well. The court has to be live to the issues in order to determine what is fair,
Mm.
insofar as if an individual is unable to work or has a limited capacity, this may have an impact upon how much capital they need or whether they need any support by way of income.
Right.
I think a more difficult area that falls under health impairments is potentially health impairments that are self-inflicted to a
Mm.
certain degree or seen as self-inflicted. I
Mm.
think those type of what I'm referring to there is things such as alcohol abuse or drug abuse.
Yeah.
Um, it is very difficult to give a answer which fits in all those categories. I think obviously if any of the viewers are finding themselves in that scenario, those factors will have to be taken into consideration, but how much weight a court attributes to those factors is a different question.
Yeah.
So
It will be a case by case basis, I
yeah,
imagine, that, you know, very much turning on the facts of each case. So this is probably an area where, if you're in this situation, this is where you would need to take very specific advice on your personal situation, perhaps.
Yeah, very, very much so. Very much so. I think,
Mm.
and from kind of previous seminars, I think, as you've said, there is a cycle
Yes.
which most individuals will go through. And I think stress anxiety forms part of that, and depression forms part of that. So if, for example, the health impairments in terms of alcohol abuse are temporary, then the court is likely to take a different stance, as if
Mhm.
it's a long-standing issue,
Yes.
which, quite frankly, is not going to get resolved very
Yeah.
quickly. So the court will be live to it, but this is why we say each case revolves around its own facts.
Yeah. Absolutely. I imagine that in most cases, if you can reach a negotiated agreement on this through working with your solicitor and so on, that's probably going to be better than it ending up in front of a judge as well. You
Yeah,
have some element of control still then, don't you, over what is agreed in ultimately.
very much so. Very much so. In my own experience, it was only a couple of weeks ago, in a court in the Southwest, the judge told, obviously, the legal representatives and the parties that if an agreement can be reached between us,
Yeah.
we can tailor it to the parties' individual circumstances down to the minute detail.
Mm.
Whereas ultimately, if it's something that has to be determined by the court, a judge might not go into the absolute minute detail. So it is very much better to have an agreement because we are completely in control of it. Whereas, obviously, if it's determined by a judge, then we lose control.
Yes. Yeah. So that leads me into some other questions around what people read online and the kind of
Mm.
misinformation perhaps that is out there. So I've read online that I'm only entitled to 50%. Is this true?
Yeah, I think there is a lot of information online suggesting that. I think
Mm.
what's important to understand is where the information is coming from. So the answer
Yeah.
to that question is partially yes and partially no. So in a nutshell, there are some principles in law that have come out of common law, i.e., law that's been made by judges.
Yeah.
So in 2006, there was a case of Miller and McFarlane. And one of the principles that have come out of that case is something that's known as the sharing principle. The sharing principle says the starting point is that the matrimonial assets, i.e., the assets that were accrued during your marriage, should be divided equally, and hence where this idea of 50% comes in. Now, the second arm of the principle says if either of your needs requires it so, we are allowed to move away from an equal split of the matrimonial assets.
Mm.
To this extent, yes, 50% is true in terms of the sharing principle, but if either of your needs demands it so, we can depart from that.
Okay. So again, it's a case by case basis, isn't it? And
It
that
is.
you need to look at your individual circumstances. I mean, that's something that's coming across very strongly. This is not a black and white area of law where there is a piece of legislation that says it's done like this. It's very much grayer than that.
Yeah, very much so. I mean, I speak to a lot of people who will come to see me initially and say, we are looking to split everything down the middle. But the elements that they're not maybe taking into consideration is that there is a disparity between the parties' income, disparity in relation to their pension provisions, disparity in relation to job opportunities because of the
Mm.
decisions that were taken during the marriage. So
Yeah.
again, they are all relevant factors.
Mm. Yeah. Another thing that might come in sometimes. So I've had a couple of clients in this position. So I've got a prenuptial or a postnuptial agreement with my spouse. How's this going to affect how we resolve our finances?
Yeah, very good question. So pre and post nuptials. So a nuptial agreement is an agreement that's either signed before your marriage, being pre, or post, after your marriage, in relation to what happens to your finances in the event that you separate. So in the UK, as it stands, the pre and post nuptial agreements are not binding to the court, insofar as the court is not bound to adhere to the pre and post nuptial agreements. However, and this is a very big however, if the pre and post nuptial agreements have been drafted in a way which takes into consideration life and how your marriage can evolve or will evolve adequately, which allows both parties to meet their respective needs, then the court will add weight to a pre or post nuptial agreement.
Right.
So
they can be persuasive.
Yes, they are. I mean, in the eyes of the law, it forms part of all the circumstances of the case that they take into consideration. In my experience, in my experience, a well-drafted pre or post-nuptial agreement, for most judges, they will stick to the pre and post-nuptial agreement. However, the caveat is that that prenuptial agreement needs to be drafted appropriately. By way of example, and we see a lot of pre and post-nuptial agreements that fall into this category. An individual will sign a prenuptial agreement, and there'll be no difference in the prenuptial agreement if the marriage lasts for 5 years, 10 years, 15, 20 years, if the parties have children. So again, all those life factors have to be taken into consideration.
Yes, and make a massive difference. So we've talked quite a lot about the court. So the other thing that I often find when I speak to clients is that many people think that it's either you apply for your divorce online and you just do it yourself, or on the other end of the spectrum, you have a really horrible high conflict court case. Do you have to go to court? And what other options are there out there?
Yeah. So for most individuals, and this is true of both divorce and finances, the individuals will never go to court. A lot of it is a paperwork exercise. The divorce is done online unless there are complications. And the finances, obviously, if they can be resolved, it's then drafted into an agreement and submitted to the court for approval. Obviously, the court is there for a reason, insofar as if an agreement can't be reached, then it serves as a way of ending the finances, especially if an individual is not compliant. So for 95% of people, I'd say maybe 95% of people that will never go to court. In relation to in relation to the other options that are out there, I think it's important to understand that there are a lot of options out there, especially when we look at how to resolve finances. Again, it comes back to the idea of the divorce process and resolution of finances is personal to you. We will do it in a way that you are comfortable with. So one of the points I briefly touched upon earlier on was mediation. So mediation is a way. Another option is known as collaborative law. So collaborative law is a method of both individuals having solicitors and then obviously having meetings together in order to try to resolve the overall objective. Okay. Again, resolution together is an option where you have two clients or two individuals and one solicitor. Or obviously there is the standard divorce route where negotiations, discussions, agreements can be reached via correspondence or any other form of negotiation that an individual is happy to take part in. So in my eyes, there isn't a one way that will fit all, because we as individuals are all different. So it's about tailoring the process to that person and making sure that they're happy with it.
No, that's really helpful. I think for people to know that it doesn't have to follow a predefined route is really helpful, and that it can be very individualized and tailored to your specific circumstances and your specific style of wanting to resolve it as well. So some more questions about the finances, because these are the ones that come up all the time. Do I have to declare all my assets?
This one's a little bit easier to answer. The answer to that question is yes. So so the law says for an individual to make an informed decision, they need to provide full and frank disclosure. Now, again, I think living in the real world, I appreciate that, you know, not everyone shares that value. Now, the risk for an individual who does not disclose all their assets is that a court can set aside any financial agreement for material non-disclosure. So if an individual doesn't disclose it, then they risk it being set aside and inevitably the consequences of effectively not providing the court a full picture.
Yeah, and having the case opened up again. That sounds, yeah, I can imagine that would be very stressful. So the next question is related to that. And I work with lots of clients who are the Form E, the dreaded Form E, which is quite a long form, quite a detailed form. Do we have to fill in a Form E? And is there something that is shorter, quicker that we could use instead?
Okay, so to answer this, and again, for maybe there are listeners out there that don't know what a Form E is. So a Form E is a document, is a court prescribed document. Usually what happens is that if you go to court or you make a financial application to the court will order you both to complete this document. In short, it's a document of about 30 pages, which asks you very specific questions in relation to your finances, such as, you know, what is your property worth, bank accounts, so on and so forth. So yes, the Form E is quite a large document, but it's intended to encompass all of your finances. In relation to, is there a quicker way or can we do it differently? The answer to that is yes. The Form E is not a prescribed form, especially when we're in a voluntary setting or if we're trying to resolve finances without going to court. The important elements to remember when you're looking at whether you use a Form E or simply saying to your spouse, look, you just provide me an outline of your financial position and I'll do likewise, maybe by way of schedules, or create a document which clearly states what you have in your bank accounts and so on and so forth, is the key consideration is around how well you know your spouse's financial position.
Yes.
With a Form E, it is far harder to forget or omit to disclose an asset because specific questions are asked of you in relation to all types of different assets. The Form E is also usually signed with a statement of truth on the back, insofar as if an individual signs a statement of truth and it's later shown to be inaccurate, then obviously we are in the realms of setting aside a financial agreement. If you are an individual who is completely happy or have a good grasp of what your spouse has, then yes, disclosure can be done via schedules, but a legal representative will then be more reliant upon the individual to spot whether their spouse has accurately disclosed everything or not.
Yeah, that's really helpful. Thank you. So thinking now about people who are perhaps at the beginning of this process, what's the information that is useful to bring into a first meeting with a solicitor when you're just embarking on this process?
Yeah. So if you have a copy or your marriage certificate, the marriage certificate is a good one to bring along because ultimately a marriage certificate is required when you make an application for divorce. Looking at divorce, apart from the marriage certificate, there is nothing that you need to bring along with you. When we look at resolution of finances, what we need to understand at our first meeting is what you have and what your spouse has. So we at Ian Walker, we use, we've got a data gathering process before our first meeting. So we will send you an invite to complete a set of questions which allow us to gather all the information we need. But obviously, if that's not an option, it's about clearly confirming what you have in terms of, for example, cash assets, investments, what your house might be worth. If you can find out what your pension is worth, that will be extremely helpful. I think most people forget about that. In our circles, it's requesting a cash equivalent value from your pension provider. You can give your pension provider a ring, or most have an online forum where you can request that. So what we need to understand is your financial position and your spouse's financial position.
Yeah.
I think what's important for me to say, and sometimes this does crop up, especially if you're living in the same house. There is, you know, if your spouse's documentation is lying around, there is sometimes the urge to bring that along just to show to a solicitor in relation to what they have. On that, what I would say is that there are very specific rules in relation to what we as legal advisors can look at, especially if that document doesn't belong to you. My advice is, ultimately, if you are taking documents belonging to your spouse without their consent, then you shouldn't be bringing them along.
Right. Okay, that's really helpful to know, isn't it? And many of our listeners might not even think of that. If you've got a collection of documents all in the same place, it would be very easy to think, I'll just take everything along with me. Yeah, that's very helpful to know. So another question, and I'm aware of the time now, so just a couple more really. We're not married and we're splitting up. Are the rules the same?
Yeah.
And this might be a very quick answer and another session in the making, I suspect.
But very much so. The quick answer to the question is no, the rules aren't the same. I do see a lot of people that will again rely on Google, and there is this myth of common law husband and wife. Unfortunately, it is just that. It is a myth. The rules in relation to cohabitating couples is very different to individuals who are married. There are also slight variations if, for example, you're engaged and you haven't got married yet. So there are specific rules in relation to that. They are completely different rules. So I think, the answer to the question is no, they're not the same, and potentially we'll cover them in a separate seminar if the viewers would like.
Absolutely. Okay. And the last question is, how can I make sure that my divorce runs smoothly? Lots of clients come to me scared that this is going to be a highly acrimonious, dreadful, stressful, horrific period of time for them, and they want some advice on how it can run smoothly from a legal perspective. And then I'll give a little bit of coaching input. From a legal perspective, what would you be saying in answer to that question?
Again, it's a very difficult question to answer because everyone is very different. In my experience, one of the key elements, especially from the outset, is to be honest with your spouse, with your partner in relation to what you are going to do, insofar as potentially look to broach the subject of divorce, and that, for example, you are looking into this and you are looking to do this. Most individuals, from my perspective, are far more receptive when they know something's going to happen, as opposed to a divorce application simply landing on their door without any notice. Again, most individuals that fall into that category, usually the defences come down straight away, and then it becomes a far more complicated divorce and drawn out divorce, whereas an initial consultation or initial chat from the outset could have easily greased the cogs. But I'm sure you will advise our viewers kind of from your perspective as well.
I mean, yes, building on what you just said, I think one of the really important things to do is to work out who you want to be in this process. How do you intend to behave? And be really clear about that. How do you want to show up as you go through this, and use that right from the beginning. Frame all of your conversations with that kind of intention in mind. I remember my first divorce, my intention was to be dignified at all times. My second divorce, it was slightly different. I set an intention to steer my own ship sort of steadily through. And those intentions are really important. And if you can share those intentions with your ex-partner, then that's also really helpful. And if you can agree on them, that you're both going to try and maintain that level of dignity, that you're both going to, for example, set some boundaries around, if you're living in the same house, for example, when you will talk about it and when you won't, those kinds of things. So setting some boundaries and some intentions, I think, is a really important thing to do. Secondly, I would say get a team around you. Even if divorce is something that you've chosen, it's still highly stressful. So to have the right sort of legal support, the right financial support, so you might need a financial advisor, and the right emotional support. And as we've said so many times in these sessions, if you can keep your emotions in check and keep them out of the process of negotiation, it will run much more smoothly, and perhaps work with somebody like me or a counsellor to help you with the emotional aspects of it, so that you can kind of keep those separate. I'd also say, look at what you can control the controllables. You can control what you do, what you say, the intentions you set, the decisions and choices that you make. And when you focus on those, that's where your power lies, rather than trying to change your ex-partner or make them do something different. Focus on you. And I think that the last couple, one is probably don't rush, take your time to get clarity, take your time to get the advice that you need. You don't have to make these decisions all in one day. Take it one step at a time. And then lastly, look after yourself. It's really important. I know it sounds cliched, but put your own oxygen mask on first. So look after yourself. Make sure that you are doing things that you enjoy, that you're spending time with people that lift you up, that you enjoy spending time with, and that you do have pockets in your day where you can put this to one side, and forget about it. Or if not forget about it, at least not be focused on it, 100% of your day. So yeah, look after yourself. Those are my top tips for that. That brings us to the end of today's session. I just want to say a massive thank you to Lev for allowing me to essentially interview him for an hour on all the questions that lots of my clients ask me. We have another session coming up in October. It's October the 19th, when we have a guest speaker coming in, another coach called Karen Kipping, who is a specialist in domestic abuse. And she is going to talk to us about domestic abuse and the court system, which I know some of our listeners may be concerned about. So I think that will be a brilliant session. So all that remains is for me to say thank you ever so much to Lev, and we hope we will see lots of you next time. Thank you very much.